Thank you for tuning in to TalkWad.com, the world's fastest growing internet radio network. Please check out all the other great shows on www.talkwad.com.
What if your customers are trying to find your business online, but instead of finding you, they find your competitors? Now, more than ever, it's time to make sure you have the right SEO to make your business stand out online. Welcome to Go Mind Your Business with Terry Bork, presented by Extreme Marketing Concepts, putting your business in front of the hungry herd of buyers who are looking for you right now. Extreme Marketing Concepts, helping you drive more traffic, dominate the market, and crush your competition. And now, here's Terry.
Hello, everybody, and welcome to another edition of Go Mind Your Business. My name is Terry Bork, and today my very special guest is Alan Rosenthal from Divorces for Men. Welcome, Alan.
Good morning, Terry. How are you this morning?
I'm doing fabulous. Thank you so much for joining us today. I'm all excited for a great program.
My pleasure.
Yeah. So for our listeners, I'm going to just share a little bit about you and who you are. Divorces for Men was established in 1998 by Alan S. Rosenthal, Esquire. Since its inception, Divorces for Men has successfully handled a multitude of family law cases, including matters dealing with dissolution, divorce, child custody, child support, domestic violence, paternity, modification actions, and adoptions. Alan S. Rosenthal was born in Bronx, New York. However, most of his youth was spent in Coral Springs, Florida, and he began his undergraduate studies at Loyola University in New Orleans, Louisiana, where he obtained a full scholarship as the principal bassoonist from the Loyola University Orchestra. Alan continued his studies at the University of Florida, where he received in June of 1994 his Bachelor of Science in Telecommunications, as well as a music minor and business concentration. Alan completed his educational studies at Stetson University in St. Petersburg, Florida, where he received his Juris Doctorate in December 1997. If you have any questions relating to Divorce for Men, specifically, you can give his office a call at 727-456-9221. Or if you have any questions about divorce and you just would like to look online, he does have a website called divorcesformen.com. Again, Alan, welcome to our program today.
Thank you.
Yeah, so let's talk about the name for just a minute first.
Sure.
Divorces for Men or Divorce for Men. How do we come up with that name for a divorce attorney?
Well, there's always been a perceived bias in the courts against men. And it was my goal to make sure that men were represented fairly in divorce court. And we are not anti-female. We're actually pro-female, and you might think, well, that seems like a dichotomy, but it's truly not, because the preposition behind Divorce for Men is, what do we tell men to do to make sure that they don't fall in the pitfalls? We don't. There are lots of traps. They go to a lot of different lawyers and they say, well, don't pay your alimony, don't pay your child support to your order to it. Well, that's just bad advice. If you know you're going to have a child support obligation, if you know there's going to be a spousal support obligation, you need to make those payments sooner than later, so you're not sitting in front of a judge and the judge is looking down at you thinking you're a deadbeat or someone that doesn't care about his family. You want to have the best appearance in front of the judge that you can from the very get-go. And, ask yourself this question: are you going to look better in front of the judge if you haven't paid support for the last 6 months because your case hasn't gone before him and he hasn't ordered it yet? Or are you going to look better if you start paying it? And there's a lot of ways to determine how much money you should pay, and that's the goal is in Divorce to Men, to make sure that men don't fall in those traps so they're starting behind the eight ball to begin with.
I got that. Okay, well, that makes sense. So it's a nice that men can go someplace and have a guy to speak to who understands maybe their needs and can talk to them on their level. That's perfect. So, well, you brought up an interesting point, alimony, and let's talk about that. Who gets alimony, and why is that person the one that gets it?
Well, as much as men don't like to pay it, it's not one-sided. Men and women can pay alimony, and alimony is based upon a Florida statute. Specifically, it's Florida Statute 61.08, And there's several factors which the court will consider in determining whether or not an alimony award should be granted. The first thing you should know, though, when discussing alimony is, well, there's a lot of myths out there. Well, I understand I don't have to pay alimony unless I'm married 8 years or 12 years, or my brother-in-law's sister's aunt, cousin, nephew's niece told me that because I'm only married for, 3 years, I don't have to pay alimony. Well, stop talking to the barbers and the bartenders people out there, because it's not accurate. First, I would tell you, always talk to a lawyer, whether it's me or someone else, to get your information, because as good intention as the barbers and the bartenders of the world are, they generally are giving you misinformation. First thing you should know is there are 3 types of marriages in the state of Florida. You have long-term marriages, short-term marriages, and what we call the gray area. Well, by statute, a short-term marriage is defined as any marriage of 7 years or less. A long-term marriage is defined as 17 years or more, and anything in the middle I like to call gray area, and the statute defines it as an intermediate marriage. Now, why are these important? Well, depending on how long you're married depends on what type of alimony is going to be awarded. Now, believe it or not, there's actually 6 different types of alimony in the state of Florida. It's not just a generic alimony. And there's basically 2 categories. One category we deem as what's called temporary alimony, and that's any type of alimony that is paid during the term of your divorce proceedings, or as in Florida we call it dissolution proceedings. And then there's permanent alimony, which is not necessarily permanent, but is alimony that happens after the court enters your final judgment. Now, the first type of alimony that we'll discuss today, it deals with what's called temporary alimony. Now, temporary alimony, essentially, as I said before, is alimony paid from one spouse to the other. It doesn't have to be a male to a female. It can be from a female to a male during the term that the dissolution proceedings are there. And it's to make sure that the parties are kept at and basically on an even playing field, so that neither party can gain an advantage based on finances. All alimony that we'll talk about today is based on need and ability to pay. It's not enough that your spouse has a need for it. You actually have to have an ability to pay it. But I will tell you this, whether the court should or should not do it, a majority of the time they look more to need as opposed to ability to pay. So that's a factor the court's going to look at. Now we get done with the divorce and we look at the other types of alimonies. The first one I'm going to discuss usually deals with short-term marriages, and it's an alimony called bridge the gap. Now, bridge the gap alimony by statute can last no longer than 2 years, and bridge the gap alimony essentially is exactly what it says. It bridges the gap between a married lifestyle and a single lifestyle. So I like to call it bootstrap alimony. It's money to help you get your boots back on. And like I said, it lasts a maximum of 2 years. The next type of alimony, which is not being used as much as it used to be, is what's called rehabilitative alimony. And rehabilitative alimony is essentially like bridge the gap, except for it can last longer. And usually we see rehabilitative alimonies lasting from 3 to 5 years. They don't have to, so it can be shorter and it can be longer, but that's the typical average. The problem with it is unlike bridge the gap, where you just go to the court and say, I need money for X to survive, you need to present a plan of rehabilitation to the court. In other words, Judge, I want to go back to school. I want to get my associate's degree. I want to go to massage therapy school. Something. I need to rehabilitate myself. So the court is not just giving you money to survive. It's like the old adage, we're not going to give you a fish, we're going to teach you to fish.
Got it.
So, and then the court hopes that you be rehabilitated and then be able to earn an income sufficient to sustain yourself without additional help. Now, most recently in the last 2 years, the Florida statute changed, and it came out with a new type of alimony, and it's called durational alimony. And like the name implies, it can actually last for the duration of the marriage. So if you're in a 7-year marriage, it can actually last 7 years. Can't last 7 years one day. The statute says only the length and term of the marriage is the amount it can be awarded to. And a big, I guess, misconception among the public is that judges are almighty and all-powerful. Well, that's just not the case. They can only do what the statutes allow them to do. And sometimes people can think, well, that's a lot. Well, sure it is. But in so doing, it used to be, before durational alimony came out, the courts really had 2 choices. Really, if it was what we call a gray area marriage, they could do a bridge the gap alimony, which would be 2 years, or they could do a permanent alimony, which we'll discuss in a minute, but that's a lot longer period of time. There was nothing really in the middle other than the rehabilitative alimony, which we've already explained. You would need a plan of rehabilitation. So they didn't really have this intermediate measure that they could do more justice with. So durational alimony basically came out to fill that void, to give judges a better opportunity to do equity within the court system. And once again, we would use durational alimony and easily a short-term or a gray area marriage. Sometimes long-term, but we generally see it more in the short-term and the gray area marriage range. Now, the last type of a payment alimony, and there's one after that, is called permanent periodic alimony. And that's the one that most men, and candidly now that women are in the workforce and we're seeing more equality of rights with women and equal pay and equal jobs and even women that are surpassing men in their incomes, we see permanent periodic alimony. And that is essentially a payment of alimony for basically life, and with this caveat, it can terminate upon the remarriage of the spouse that is receiving the alimony. It can terminate upon their death or your death, or based upon a cohabitation. And it's not enough that they're living together, though. The cohabitation that is talked about in the statute is what's called a supportive cohabitational relationship, which essentially means you're not just living together, you're living basically as a married couple. I like to refer to it as a de facto marriage.
Okay.
It's, you're only not getting married so you can keep getting the income from your spouse because you knew upon remarriage you would lose it. But the legislature finally realized that we're not living in 1950s anymore, and people don't always get married anymore. They and to use the term shack up, you use the term from 1950s, and they as long as we're going to go there. With that said, they have stern requirements for terminating the alimony. You're not just living together, you're sharing bills, you're going on vacations together, you're basically holding yourself out to be married, and that is one of the bases to terminate it. And another way to terminate a permanent alimony would be based upon what we call a modification. And a modification of alimony can be or can occur when there's been what we call a substantial, involuntary, permanent change of circumstances. Something's happened. Maybe you've lost your job and it's been over a year. You've been injured and you're no longer able to make the money you were making. There's a bunch of reasons that would constitute substantial involuntary change, and that's one way. And the last way is retirement. Now, I want to caution everyone out there when I talk about retirement, because you can't just retire at 40 and say, well, I guess I'm retired now, and I heard this guy on the radio say that we could terminate my alimony because I just quit my job because I listened to that guy. That's not what I said. Okay, so retirement is a very, very small category for that. You have to reach the age of 65 before even considering it. And essentially, there's a case out there, and I'm not going to get all technical with y'all, but other than tell you the case out there is called Pym versus Pym. And essentially, Mr. Pym tried to terminate his alimony, and he went in and he filed for that substantial change, but the court basically said, yeah, that's not going to happen, sir, because retirement on your case was voluntary. It wasn't involuntary, so you don't qualify. But he didn't think that was really fair. And basically, I'll change the facts a little bit to make it easier to digest, but it's, well, wait a minute. If I was still married, I was going to retire at 65. Nobody would have cared. But now that I'm paying money to my ex-wife, which I didn't want to start to pay with to begin with, I'm stuck forever and I don't get to retire? That doesn't seem quite fair. Well, thankfully, audience today, that it's not fair, and it was changed. What the court said was essentially this. We're not going to give you a modification, but what we are going to do is let you get your foot in the door. And if you want to retire at 65, we're going to say that retirement at age 65 constitutes an involuntary act. So we'll let you get in the door. And then we're going to listen to all the other factors and determine whether or not a modification should be granted in your case. And that's basically how the Pym case worked. But there was one other caveat the court said in regard to the case says, if you retire and taking away the money that you give your wife leaves her destitute, or him, depending on who's paying, we're still not going to abate your support, because let's just face it, if it's the state paying for your spouse or you, guess who's paying? It's not going to be the state.
No. Okay.
So that deals with permanent alimony. And the last type of alimony the court can consider is something called lump sum alimony, and it can be used for a multitude of reasons. But basically, it's a buyout of a payment plan. Let's put it into a situation where it was a bridge the gap payment, maybe. We'll do 2 years of alimony. Let's say your payment was $1,000 a month for 2 years. So what do we got, $24,000? What we would basically do is a present value calculation of funds over time and have you pay it all up front instead of paying it over time. So maybe it would be like, instead of paying $24,000 over the next 2 years, you'd pay like $18,000 up front and be done with it. The problem is most people don't have that kind of money.
Right.
To pay that up front, so most people don't deal with that circumstance.
I got that. Okay, great. If you're just joining us, I am Terry Bork, and you're listening to Go Mind Your Business over here at the Talkwad Radio Show on all your business radio. My very special guest today is Alan S. Rosenthal, Esquire, with Divorce for Men. If you have any questions about divorce, give him a call at 727-456-9221. Alan, can you explain what equitable distribution of assets means?
I would be happy to.
Okay,
It's one of my favorite subjects, Terry. No.
Good.
Equitable distribution is essentially how the court in Florida divides marital and assets acquired during the term of the marriage. It's essentially, it's pretty simple. Everyone's going to get this right off. It's essentially starts off as a 50-50 division.
Mhm.
And I say it starts off that way because don't get this from the conversation. It's not always 50-50. It doesn't have to be 50-50. That's why it's called equitable distribution and not equal distribution. The court can do equity. Most of the time, though, you're going to find it starts with the presumption of a 50-50 division. And once again, we're talking about marital assets and marital liabilities, and let me explain what they are. Under Florida Statute 61.075, which is the equitable distribution statute in Florida, it talks about, how we divide these things. Well, what constitutes a marital asset and liability? I'm glad you asked, Terry.
Okay, yeah. Do tell.
What marital assets and liabilities are all assets or liabilities which are acquired during the term of the marriage. That's from the date you get married, the date you say I do, and you put the ring on your finger, to when the judge or to when you file your divorce petition, okay? Or prior to filing your divorce petition, if you enter into basically a postnuptial agreement dividing your assets in that regard. But essentially, once again, we're going to start with a 50-50 division, and what will change that 50-50 division is two legal concepts. One is called marital waste, and marital waste is whereby one party uses a marital asset for a non-marital purpose. Let me give you an example. Let's say you and I were married, Terry, which
Okay.
would be odd because I married him. I don't think my wife would appreciate that.
No,
But let's
that's
say that
okay.
was true. We're married, and I decide to get a girlfriend, and it's bad enough I'm already cheating on you, but now I'm going to take money that I've earned during the term of our marriage, which is marital, and I'm going to go buy her a nice Rolex watch. Okay, now I've just committed marital waste. So what the court's going to do essentially is determine how much money I've spent outside the marital relationship, not furthering the relationship, which was not a good idea on my part.
Mhm.
So now the court is going to give my spouse, you, an equal share of what I've basically taken out to even out the playing field. They're going to take the remainder of the assets then and divide them equally.
Mhm.
So they're just basically, is it a 50-50 division? Yeah, if I wasn't cheating on you and spent money on a Rolex watch for my girlfriend, it would have been 50-50, but I blew it.
Okay.
Okay? Yeah, it's my fault. I'm sorry.
Okay.
I didn't mean to. Will you
Yeah.
forgive me?
No. No, that's probably why we're getting divorced.
That's why we're getting divorced. She can't forgive me. Yeah. Sorry, I won't do
It's all
that
good.
again. My
it's
bad.
all good. It's all good.
All right.
Okay, that makes a lot of sense, right? Isn't that the right answer? No,
That-
no, I don't forgive you.
I don't know.
Yeah, when you're in that divorce thing, I don't know that you always have that positive conversation.
You usually don't.
No.
Yeah, that's why I have a job.
Yeah,
So,
so I get that.
so
Well, let's talk about the kids for a few
Sure.
minutes, if we could.
yeah.
Child support. How much child support does somebody get, and who has to pay for that?
Well, it's a tough question to answer. It's simple, but it's difficult, and let me
Okay.
explain why.
Got it.
If you could say how much child support would I pay to my spouse, Alan, I could say, well, that depends, and this is what it depends on. Child support is based on a formula,
Okay.
and that formula, it basically takes your net income, and we'll stay married and we have kids now. Your net income, my net income, and we stick it into a formula. And then that formula basically spits out a number based upon the amount of children. But the statute recently has changed on that, and so now, it's changed additionally. There used to be what we called the 40% rule, which meant if you had at least 40% of the overnights with your child, you would get a break in child support. And we'd use what's called the gross-up method of calculation for child support. Other than that, you'd use the standard formula. Well, the law recently changed, and that number changed to 20% of the overnights. So now, when calculating child support, it's important to know what the time-sharing arrangement is going to be with your children. Because without knowing that, I could tell you, well, if it's going to be under 20% of the overnights, your child support would be X. If it's going to be over 20% of the overnights, depending on specifically how many overnights, it's going to change the child support amount. So your child support is directly affected by the amount of overnights that you spend with your children.
Okay.
And that's a big difference. So, but ultimately what you need to know is if you would want to do it, one, there are calculators online. There are many different websites that there are calculators where you can call an attorney to have them do that. You're going to need to know these facts. Your net income, your spouse's net income, the amount of overnights that you're going to have with your child or children, depending on the case. If there's daycare for the children, how much that daycare is, who's paying it. If there's health care for the children, how much that is. And then as far as to get to your net income, we start off with your gross income. And how we get to net income is regular taxes. And if you're paying health care for yourself, you're entitled to deduct that. And if you have mandatory retirement, you're allowed to deduct that to get down to your net. And that's the way essentially child support works.
I got that. Okay. What happens if one of the spouses is paying child support and then all of a sudden they just stop paying?
Well, I would call Guido. No, don't do that. Don't call Guido.
You probably don't want to do that at all.
That's the Bronx kid in me coming out. No, what you'd want to do is I would always suggest calling an attorney for this because it can get complicated. But what you're going to end up doing is filing what's called a motion for contempt against your spouse for failure to pay child support. And basically, a motion for contempt basically is, well, first of all, a motion is basically you go to court saying, Judge, I want this. That's all a motion is a request to the court of what you want. And then you ask the court for the relief you want. So basically, if your spouse isn't paying you child support, you go into court, say, Judge, I'm filing a motion for contempt for his or her failure to pay child support. And, he hasn't paid for X amount of weeks or she hasn't paid for X amount of weeks. I'm owed this amount of money, and this is the relief I want, And the court can, take away his driver's license or her driver's license, and there are other sanctions, monetary, that can be imposed, and things of that nature.
Got it. Okay. I have two more questions about child support, Alan. The first one is, what can, situations in life change. They change every single day. What happens if all of a sudden I can't afford to pay my child support anymore if I am the person that's responsible for paying that child support?
I'm glad you asked that because that's a very an important question that needs to be answered. The first thing you need to understand is your child support is always modifiable. It's not something you're stuck with for life. You can modify it. Your spouse can modify it. And like alimony, we talked about a substantial and voluntary permanent change in circumstance. If there's a change in circumstance, you can file for a modification of support. And my suggestion to anyone paying child support that can no longer afford to pay it, you need to get to the courthouse sooner than later. Whether you file with an attorney or you file by yourself, you need to file what's called a supplemental petition to modify your child support. And because what you need to know is the longer you wait, you're still on the hook for the support that's been ordered, because whatever's been ordered, you're stuck with. The minute you file your supplemental petition, does it stop? No, it doesn't. But the award by the court should be made what we call retroactive to the date of the filing of the petition. So it is very important that you file that petition sooner than later, because if you wait and you wait and you wait, 2 years later, let's say you have now an arrearage of $20,000, well, guess what? You're stuck with that arrearage, and the court cannot relieve you from it. You've put yourself in the proverbial hole. So make sure that if you get into a situation where your support needs to, you can no longer afford to pay your support, you need to file that supplemental petition to modify it.
Okay, great. Now, can anything happen to me if I don't pay it at all?
Yeah, sort of like what we talked about earlier. Your spouse can file a motion for contempt, or if your payments are through the Department of Revenue, they can file actions against you. They'll send you notices of delinquencies if you're failure to pay support. They'll set hearings, taking away your driver's license. Your tax return can be intercepted through federal intercept by the federal government. So there are a lot of penalties you can face by not paying your support. So if you're in a position where you can't pay it, make sure you act. Don't just bury your head in the sand. The ostrich defense doesn't work. If I put my head and I close my ears and I spin around 3 times, it'll just go away. That doesn't work. Don't do that.
Okay, got it. Okay, no, that's really, really helpful. And then it doesn't matter, which one of the two of you is paying the child support. Just make sure court's not a bad thing. It's there to also help and assist.
Correct. Yeah.
So, got that. You are listening to Go Mind Your Business here on the All Your Business radio show at the Talkwad Network. My name is Terry Bork with Extreme Marketing Concepts, and my guest today is Alan S. Rosenthal, Divorce for Men. If you have questions for Alan, you can reach him by calling 727-456-9221. We're going to take a quick break, and we'll be right back after this commercial message. We are back. I am Terry Bork with Extreme Marketing Concepts. Business owners today have one of two problems. Either they have an outstanding reputation and nobody knows about it, or they've got a terrible reputation and everybody knows about it. For help with either one of these things, we can help. Give us a call at 813-863-1452. Again, we're speaking with Alan S. Rosenthal, Esquire, from Divorce for Men over in St. Pete. I want to talk to you, Alan, if I can, about custody. I know a lot of dads kind of get upset because they say the mom always gets the child custody. Is that true?
If it was true, I wouldn't have a job, Terry.
No.
Moms
Moms might not be the best person for that child.
And that's exactly right. The courts take into consideration Florida Statute 6113, which is the best interest of the child when making any child custody determination. We don't actually use the word custody in Florida anymore. It's an outdated term. The statute changed. We have what's called primary residential, essentially primary residence and secondary residence. And at the end of the day, what we're looking at is time sharing. Who's what we call the majority time sharing parent and the minority time sharing parent. There used to be, I have custody. I'm the majority. What used to be called the primary residential parent and the secondary residential parent. We don't have those terms anymore. Now it's majority and minority time sharing parent as far as that goes.
Mm-hmm.
What we have is basically shared parental responsibility now in the state of Florida and sole parental authority. And under a shared parental responsibility, basically both parents continue to have full rights regarding the children, making decisions regarding the health, safety, and welfare of the minor children. And basically, you're co-parenting. The only difference is you're not doing it from the same household. The other is called sole parental authority, and that's when we have one parent who has got some serious issues, usually drug-related or criminal activity, or they're just not all there. They shouldn't make decisions for themselves, and God forbid they shouldn't make any regarding minor children. So, but as far as custody goes, it's not always to mom, and we're seeing a lot more courts award time sharing and the majority to dad. The reason we've seen it historically that moms have gotten custody is, and I'll use the term loosely for our listeners, not to confuse them, but the reasons moms have gotten custody is because, let's face it, back in the day, we'll go back to Ozzie and Harriet, and we'll go back to Ward and Beaver Cleaver and all those things.
Sure.
The moms were stay-at-homes.
Got it.
Dads went out, they earned a living, and they were out doing everything they needed to. And did it make them bad people? No. Well, somebody had to pay the bills.
Sure.
And of course, staying at home, probably the toughest job ever. But moms were there. Moms were dealing with the children all the time, so they had a greater familiarity of the children's needs and wants and the like. And now we're seeing a lot more, obviously, two-income households. People can't make it with one. So moms and dads are splitting the duties that were traditionally held by moms. And I'm always offended, candidly, and a lot of other people that come to see me that there's some that moms are better parents than dads. So that's just not the case.
No, I don't agree.
I'm happy to say that I've got two wonderful children at home, and I'd like to think that I'm as much been capable for their upbringing as their mom has.
Sure, absolutely.
So yeah, we're seeing courts typically they just weigh the factors. Now let's just be honest. Let's say dad's a brain surgeon and he's out of the house. 7 days a week, sporadic schedule, and mom's at home. Is mom going to get custody? Let's wake up, guys. Sure, she is.
Mm-hmm.
Okay. Now, on the other hand, let's say mom and dad work out of the house equally. Then dad always brings the kids to school in the morning. He's doing their homework at night with them. He's actively participating. The court's absolutely going to give him equal weight to determine whether or not he should be a majority, a time-sharing parent or the minority time-sharing parent. So there's a lot of factors to consider. Now, the statute, basically, it's my interpretation, and some people will argue with me, but that's their right, I guess. It's supposed to start off with the presumption that both parents are to have equal time sharing. But I'll just be honest with you, if you're in Pinellas County listening to that, that's not the case. Pinellas County judges traditionally do not start with a 50-50 time presumption. If you're in Hillsborough County, you'll see that they do the exact opposite. So you've really got to know, it's important to know the law. It's more important sometimes to know the judge and what your judges in your county and your area will do.
Mm-hmm.
So you might have the greatest lawyer in Pinellas County. I don't know that I'd hire him to go to Orlando.
Right.
Not because he's not a good lawyer, but because he doesn't know the customs and traditions and things that are going on in the other area.
Got it.
So that's things you want to work about. So understanding most judges in this area are going to award a majority time sharing and a minority time sharing.
Mm-hmm.
A lot of the judges believe that splitting up the the school week is not a good idea for the children, and that opinion is shared by a lot of psychiatrists and different specialists and that are involved with children, and as such, I don't know what they're doing is a bad thing. And then some people argue, well, yeah, but isn't it better for everyone to see their kids more often? Because, when I was married to my wife or I was married to my husband, I got to see my kids every day, and they seem to be doing really well. So I'm thinking how my presence outside the home or outside the children is going to help them. Well, every decision that judges make is on a case-by-case basis. And just because the courts don't generally, in this area, start with a 50-50 timeshare arrangement doesn't mean the courts don't do it. And I've been involved in many cases where the courts have, in fact, awarded what we basically call rotating custody, which is basically where each party has 50-50 time sharing. It is just not the norm, so don't go into your dissolution or your paternity case thinking that it's going to automatically be a 50-50. More likely than not, it's not. And if you and your spouse are not getting along, or you and your significant other aren't getting along, it is more likely that the court is not going to award a 50-50 time sharing, because if you're not getting along, they don't want to keep you together that much, honestly.
Got it. Okay, that makes tremendous sense. Thank you. Now let's talk about, a couple, they're together, they decide, it's not working, we need to get a divorce. What are the requirements for filing a petition for divorce?
Well, what you'll learn is we're a no-fault state for divorce.
Mm-hmm.
Okay, and let's clear this up first and once and for all for at least the people listening. No fault doesn't mean the bad stuff you do doesn't come into court. But what a no-fault divorce in Florida means is that all you have to do to ask a court for a divorce in the state of Florida is to say that your marriage is irretrievably broken. That means there's nothing the court could do to repair your marriage, and that marriage counseling would not assist you, and there's nothing that you could do to put your relationship back together. So that's what you basically have to prove in Florida to get a divorce. You don't have to prove adultery. You don't have to prove mental cruelty or abuse or any of those things. That's what you have to obtain when you're in a fault state. It doesn't mean the court can't take into consideration if you beat your wife or you beat your husband, that for terms of purposes of alimony or equal distribution or support issues, that the court can't take those things into consideration, because if you think that's the case, you're substantially wrong, and you need to amend your thinking on that. But it just is determining whether or not the court will actually grant you a divorce from your spouse, is just that your marriage is in fact irretrievably broken.
Okay, got that. Okay. Now, once that divorce is final and you get that piece of paper, is everything final? There's no going back, or can changes happen, and can you modify your agreement?
Well, that depends, because like I said, we sort of talked about how child support's always modifiable, and certain types of alimony are modifiable. Not all. You can actually create a circumstance with alimony that says it's non-modifiable or non-convertible, non-extendable, non-changeable, and you're probably stuck with it. There are certain circumstances where you can get out of it even when it's non-modifiable, but that is not the norm. But as far as whether you can change it, after you have a final divorce decree, you're generally stuck with it. You've either agreed to it through what's called a marital settlement agreement, and the court incorporates that into your judgment, or you have a final hearing and the judge makes a ruling. Final judgments say final in the title because that's what they are. They're final. They're final judgments. Now, can you change them? Yes, there are reasons to set aside judgments. There are reasons to seek changes. Generally speaking, equitable distribution awards, the division of personal property, debts, and assets, they are not modifiable. They're an entitlement right that once they're granted, you're pretty much stuck with it. But issues, once again, with support, child custody, those issues can be modifiable. Additionally, let's say you got a really bad deal, and you were married to the biggest liar ever who committed a bunch of fraud. Can you set aside an agreement? Yeah, you can. You can do that through what we call a 1.540 motion, and it's your motion to vacate a final judgment. And you have up into a year after the judgment's been entered, although you're supposed to do it in a timely manner, but you have up into a year, generally speaking, to set aside an agreement. Now, there is no time limit based upon fraud and a financial affidavit. So if, let's say your spouse said, I only have $20 in my bank account, when he actually had $200,000 in an offshore account, in the islands. Yeah, there's a really good chance you're going to be able to set aside your divorce decree, and the judge is going to reallocate it. In fact, there was a case, it was out of state, it was in California, but a judge in Florida posted it on his door. Basically, the party had committed fraud on their affidavit, and the wife in that case had obtained a lottery ticket prior to the prior to the divorce actually had won the lottery.
Oh no.
Didn't disclose it. And basically, the husband found out about it after the fact and went back to court and said, "Judge, what's the deal? I don't get this. She won the lottery, and it was during the term of the marriage. So correct me if I'm wrong, but isn't that a marital asset?"
Right.
And the judge said, "Well, yeah, it is. So you're entitled to half, sir. And as a sanction, which is basically a bad thingy, sanctions is something the court does to people that aren't doing what they're supposed to do. He sanctioned her by giving the husband the entire lottery."
Oh my goodness!
I know,
wow.
terrible, right? So yeah, she walked
Bummer.
away with nothing.
Plus legal fees.
Yeah, plus legal fees. So yeah, so
Ooh.
don't do that. Don't lie, cheat, or steal. I mean,
Ooh,
it's not a good idea. I mean,
wow.
we have mandatory and automatic financial disclosure in the state of Florida. It's governed by Rule 12.285, and essentially, without even the other side asking, we've got to give a host of different documents to the other side without them asking to disclose our finances. That's you need to do that, people. You need to disclose everything you have to the other side, and they do the same to you, and then you can enter into a fair and binding agreement. And if that happens, generally speaking, there's little or no chance that the agreement is going to be set aside or a final judgment is going to be set aside.
Okay, that makes sense. Is there a residency requirement in Florida before you can get a divorce?
There is. Prior to getting a divorce in the state of Florida, you have to be a resident of the state of Florida for 6 continuous months prior to the filing of your divorce petition. Only one party has to be a resident of the state of Florida, though, so not you and your spouse. Now, which means, let's say you were living in Georgia your entire marriage, and then you just come to Florida. Can you file for divorce? Yes, you can after you're resident for 6 months, but understand this. The court can only divorce you. It cannot deal with issues dealing with property rights or alimony because your spouse really isn't subject to what we call the jurisdiction of the state of Florida. Now, go ahead and ask me if they can deal with matters dealing with children.
Can they deal with matters of the children?
Once
Alan?
again, I'm glad you asked me. If the children are still residing in Georgia, the answer is no.
Okay.
There's a document called the UCCJEA, and that's called the Uniform Child Jurisdiction and Enforcement Act, basically, the UCCJEA. And that basically gives the court jurisdiction to deal with matters dealing with children. Now, if you leave Georgia and you move down to Florida and you're down here for 6 months, and the children are down here 6 months, then the Florida court would then have jurisdiction over the minor children to make rulings about the minor children, because it basically is determined on the home state of the minor child. So, the Uniform Child Custody Jurisdiction and Enforcement Act. It's a mouthful. That's why we can say UCCJEA.
Yeah.
But that act allows the court to make decisions regarding the kids.
Okay, that's perfect. So it's okay to be already separated from another state. You come down here,
Right.
and then you have to live
Once
here.
again, all you can do though is get divorced.
Got
We can't deal with any other matters unless the
Okay.
UCCJ is meant for child
Right.
custody matters. But
Or
other
you
than
need to go
that,
back up there to
or-
Georgia.
exactly. So sometimes people will say, I've been down here 6 months. My spouse is still living up there with the kids. Should I get divorced down here? I mean, you can, but you're wasting your money, folks. You'll be
Sure.
divorced.
Right.
But and if you're looking for a quick divorce, that might be the way to go. But if you want to make sure your property matters are dealt with and issues dealing with support and your children, it's probably gets worth it to deal with that issue up in the state that you're coming from.
Got it. Okay. Alan, I think that a big question that couples have to determine, especially today, is who gets the house. How's the best way to position that for somebody who's in this situation?
Well, it's really funny that we talk about the house because there was a time where people always wanted the house. Now people just want to get rid of it. It's become that
We get
big
upside
white
down.
elephant.
Yeah.
Right. It's like, who wants it? It's usually underwater. As far as that goes, there's basically 3 dispositions of the house, essentially. One is you sell the house and you split the proceeds.
Mhm.
No brainer, right? The husband can get the house or the wife can get it. And if you're going to get the house, you're going to buy your spouse out of it. So let's say, once again, we're married again, and we're one of the lucky couples that actually has equity in our house. So let's say the house is worth $200,000 and we owe the bank $100,000. Well, then I've got $100,000 in equity that needs to be divided. So I need to buy you out, Terry. So I'm going to give you $50,000 because I want to keep the house. And you said you didn't care. Now, if you both care about who gets the house, well, that complicates matters because you both can't continue to own the house. So that usually forces the sale of the house, and it's going to get sold eventually. And that's what we call a partition or it's called a petition, for Partition Act, which is where you can ask the court to sell the house. And when the court gets that type of a pleading, a petition for partition, the court is going to move that the house gets sold and then the proceeds get divided. Nothing stops either party, though, from going and participating in the sale, generally speaking, and then buying it. So it usually gets worth it to figure out who really wants it more and just buy it from your spouse or vice versa, or just selling it.
Okay, cool. That helps. Can a couple save money by sharing an attorney together?
You could probably save money if you can find an attorney that will do it. Generally speaking, attorneys will not represent both people. There's a huge conflict there. Um, uh, Candidly, the only way I would ever represent two people, and I've done it, but I've done it very, very sparingly, is when both people have already signed an agreement. They're just not really familiar with the process, and they just would feel more comfortable if a lawyer filed it for them.
Mm-hmm.
Then I'll do it. But when you've got to get in there and you've got both people that come to your office, you have an obligation as attorney to tell each party what their rights and obligations are. But if I'm telling each party what their rights and obligations are, I'm not doing a really good job for one by telling the other one you should be seeking alimony from this person. And I'm telling the other person, well, try to get away without paying alimony. That doesn't really work. So there's usually huge conflicts, and it's usually an extraordinarily bad idea. Now, nothing stops you from hiring one lawyer, but understanding that only one party is going to be represented. Like, I'll have lots of clients come in and say, does my spouse need a lawyer? Your spouse doesn't need a lawyer. And usually what I'll recommend is, like, if it's basically like the man comes to me and says, Al, look, we've agreed, this is what we want. I need somebody to draw it up. So they'll say, look, she's going to get the house. We're going to do a 50-50 rotating with the kids. We want you to figure out child support, put it through the guideline for us, and draft up an agreement. So I'll draft the agreement, and then usually what the other spouse will do is just get the agreement and have a lawyer review that agreement as opposed to retaining one for full boat, because it's expensive, especially when the parties have already figured out what they want. There's no point in giving attorneys your money when you can spend it on yourself and your children. So, yeah, that's a situation where just one party would hire a lawyer, but that party would solely represent, the attorney would represent that party only.
Okay, great. How does somebody go about selecting the right divorce attorney to handle their case? Or is there such a thing?
Well, you know what? The right attorney for one person may be the wrong attorney for others.
Sure.
When I'm talking to clients, I tell them, look, I know the law. Most attorneys know the law. It comes down to personality. You're going to have to know your attorney. You're going to, get personally involved with your attorney to the extent that you're telling them about the closest things in your personal life that you don't even share with your best of friends, because they need to know most of the time. So personality certainly is important. And certainly make sure that you sit down with any attorney that you're going to hire, and before you hire them, interview them. I mean, I sit down with, I charge $75 for consultation. My hourly rate's $300, so I do a very abbreviated thing, and I sit down with clients for about an hour of my time, and during that time, I explain to them all their rights, their obligations, and what can happen in their case. And by the end of the time, I've talked to them, they've talked to me, and as much as they're interviewing me, I'm interviewing them whether I want to take them as a client, because I don't take every client that walks through my door.
Sure.
And certainly I don't get hired by everyone that walks through the door either. And I let them know personality is a big thing. And if you get along with your divorce lawyer, that's great. So I always say try to do that. And as far as my consultation fee, if at the end of our consultation you decide you want to retain me, I actually do waive that $75 cost. So it's basically it's there as a stopgate measure, because I'm really busy, unfortunately, or fortunately, as the case might be, and I don't have time to get to talk with everyone. So if you want to spend some time with me, and I'll tell you all about divorce law, and you really want a divorce, and you hire me at the end, I waive the $75. But at the end of the day, if you had nothing better to do on a Wednesday, and you just wanted to figure out how divorce works in Florida, it's going to cost you $75, which is you're going to find is real reasonable.
Sure. Okay. Absolutely. Is there anything else that maybe we haven't talked about today that you'd like to share with our audience?
I'm feeling pretty good about what we've talked about. But to readdress your question of how to find a great divorce lawyer, certainly Google it. Get on Google, look for bar complaints, check with the Florida bar, see if your lawyer's been disciplined. Talk around, see if they're, and I hate to use the term, but if they're a fee churner, if they're more impressed with lining their own pockets with your money than helping you with your case. There's a lot of good lawyers out there, and there's a lot of bad lawyers out there. Just make sure you're getting a lawyer who's more concerned about you than they are about themselves.
Got it.
And check, like I said, check Google, look for, are these people being bad-mouthed online, or are they getting, raves? Are they being grieved by the Florida bar, or not? These are certainly important questions you need to know about your lawyer.
I got that. Okay, excellent advice from an excellent divorce attorney. We have been speaking with Alan S. Rosenthal. He's an attorney from St. Pete. His office is you're on Central. What
It's
number?
3909 Central Avenue, St. Pete, Florida 33713. That's 3909 Central Avenue, St. Petersburg, Florida 33713.
Got it. Okay. And again, divorcesformen.com is full of all sorts of information that you can review to help you if you are in the midst of a divorce or know somebody in the midst of a divorce and you have questions. You can give him a call, 727-456-9221. My name is Terry Bork with Extreme Marketing Concepts. You have been listening to Go Mind Your Business here on the All Your Business Radio on the Talk WAD Network. I'm looking forward to joining you again next time. But until then, I remind you to go mind your business. Have a great day.
Thank you for listening to Go Mind Your Business with Terry Bork, presented by Extreme Marketing Concepts. If you want to drive more traffic, dominate the market, and crush your competition, find out how by visiting our website, www.extrememarketingconcepts.com. And join Terry next time for another episode of Go Mind Your Business.